Hear ye, hear ye. Court of Appeals for the First District of Texas now in session. Pursuant to adjournment, can I take the Constitution and the court?
Be seated. Welcome to the First Court of Appeals. My name is Justice Gordon Goodman. And to my left is Justice Richard Hightower, and to my right is Justice Sarah Beth Landau. We're here today to hear the case of Avishai Ron, individually and a trustee of the Susan and Abby Ron. Excuse me. We started that over. The case style is Suzanne Ron versus Avishai Ron, individually and as trustee of the Suzanne and Abby Ron 2012 Children's Trust. It's case number 0122-00731-CD. I see that appearing for the appellant is Ms. Melissa Lorber.
Yes, Your Honor.
And Ms. Lorber, we've set aside 15 minutes per side, unless you feel you need more time.
Well, I'd like to reserve 5 minutes of that time.
Sure.
For rebuttal, and I guess I'll leave it up to you guys whether I need more time if there's questions.
We can do 15 or 20, whichever you'd rather.
20 sounds good.
Okay. And you want to reserve 5 of the 20 for rebuttal. Okay. And then we have Mr. Andrew Mead here for the appellee.
Yes, sir.
And would you like to also introduce your
Sam Aaron is with me, and Leanne Pinkerton as well with me from my firm.
Very good. Welcome. With that, we'll get started.
May it please the court. Although the facts of this case are unusual, the governing law is very clear. The Supreme Court has instructed multiple times that arbitration is a matter of contract. It's a matter of consent, not coercion, and parties cannot be compelled to arbitrate issues they did not agree to arbitrate. Arbitration is a way to resolve just those issues the parties agreed to submit to arbitration. And when an arbitrator decides an issue not submitted to arbitration by the parties' agreement, he exceeds his authority, which is a ground for vacating arbitration award under 171.088A3A. In this case, the arbitrator issued an award of $334,000 to Gary Stein, who is not a party to this arbitration, with whom the parties to this arbitration did not agree to arbitrate, and he created damages that did not exist at the time of the arbitration. The arbitration agreement in this case is solely one part of one sentence in the mediated settlement agreement, and it says, the parties that signed this were Suzanne Ron and Avishai Ron. The parties agreed to submit only disputes related to this agreement the parties agreed to submit any dispute related to this agreement to Alan Levin for binding arbitration. Again, that's Suzanne and Avi. It's not Gary Stein, and it's not the Children's Trust.
Can I refer you to the decision by the Fifth Circuit Court of Appeals that says the MSA contains an extremely broad arbitration clause requiring the parties to submit any dispute related to this agreement for binding arbitration. They go on to say that we conclude that Suzanne's... sorry about that. There's something going on with our audio. I apologize. If you'll just have a seat for just a moment.
Okay.
We'll try to get this solved before we continue.
Remind me of some kind of dog
Apologize.
I think it's just you.
Well, if we have to, we can.
microphone,
Please,
while
please.
we proceed if we need to.
Yeah.
But I don't actually know how to do that.
Nor do I.
Does that do recording it for our open meetings assessment?
Let's see, as long as the courtroom doors are open.
At least you'll always remember this oral argument.
First time we've ever had this.
We good?
You can go ahead.
Okay.
Oh, okay. Ms. Laura, I was in the middle of trying to say,
Yes.
there's another provision in the Fifth Circuit decision I wanted to call your attention to. It says, for these reasons, we conclude that Suzanne's allegations against Avi involving the Children's Trust squarely implicate the terms of the MSA and thus fall within the scope of the valid arbitration agreement contained therein. Is this not already litigated, that question?
No, Your Honor, and there's a couple of answers to that. The first part is, at the time that the case went up to the Fifth Circuit, only Suzanne had brought claims in this case. There were no claims by Avi or by the Children's Trust, and so the Fifth Circuit and the lower courts were looking only at whether Suzanne's claims were subject to arbitration, and they held that because Suzanne's claims referred repeatedly to the MSA, that they related to the MSA. But that is a different question whether much later, when the case was already in arbitration and Avi asserted claims individually, and the trust never did assert claims against Suzanne, just Avi individually did. But the question of whether those claims that the Children's Trust now says they brought, but never actually pled, would have been subject to arbitration is not something that was, they hadn't been pled at the time of the Fifth Circuit opinion and hadn't been addressed. But I think maybe your follow-up question, a dispute about how much the Children's Trust may or may not owe to Stein does not relate to the MSA when neither the Children's Trust nor Stein are parties to or at issue in the MSA. It's separate from, the MSA was deciding issues related to a divorce and a separate family trust.
Is it relevant that those claims had not even come in existence at the time of the MSA, the claims for attorney's fees?
Yes, I mean, I think also because to the extent that the MSA includes a mutual release of, and again, it's only a mutual release as between Suzanne individually and Avi individually, because they're the only parties, but it was only up to the date of the MSA. So anything that happened after the date of the MSA, I mean, Suzanne could not have, at the time of the MSA, envisioned that there would be future litigation in which the Children's Trust would seek indemnity from Stein, because none of that had occurred yet.
But doesn't the MSA also have a provision under the miscellaneous category saying that disputes arising out of this agreement shall be subject to binding arbitration? It surely is talking about future disputes, not past disputes.
Right, it says claims related to this agreement, and again, I would point out that claims between the trust, which is not a party, and Stein, which is not a party, is not something that relates to the agreement. The agreement addresses things completely separately related to equalization judgment and the divorce and family trust issues. And again, there's two trusts. There's the family trust that Suzanne had been in charge of, and then the Children's Trust. And the Children's Trust and Stein are just not a part of this document at all. They're not, and so a dispute between them about how much they may owe is not something that's subject to this arbitration agreement. But this goes one step further. I mean, even
Sorry,
if the...
can I stop
Oh,
you?
sorry, yeah.
The MSA does mention the Children's Trust. I know they're not a party, but they're mentioned.
Only to the extent that going forward, Avi would be the trustee.
Right.
And so that's something that the arbitrator pointed out during the arbitration, is that the trust could not have been a party to this. Avi could not have signed on behalf of the trust to the MSA because he wasn't the trustee at the time until after the MSA went into place. And so again, that goes to show that this is an MSA between Suzanne and Avi. But what happened here is even more attenuated than whether the Children's Trust was a party to this or not. It's the fact that the judge created damages that did not exist and then ordered Suzanne to pay those damages to a third party with whom she had not agreed to arbitrate.
Do you mean the arbitrator or the judge?
I'm sorry, did I say judge? The arbitrator. The arbitrator created $330,000 in damages, and at the end of the day, it's Suzanne that's out that money and Stein that gets that money. And there's no doubt she did not agree to arbitrate anything with Stein.
Can I ask you just one question? Is the dispute as to whether she owes anything or just how much she owes?
There's two disputes.
Because this has to do with the costs incurred by her bringing the federal litigation against the trust and the trust protector. And is it not clear that she owes money to reimburse the trust or the trust protector?
The question, Your Honor, is whether that question, if she owes money to the trust protector for Stein's fees, is an arbitrable issue that was subject to arbitration. And it was not. I mean, she of course says she doesn't owe anything to Stein, but the bigger question, the question that we're challenging, is not whether the arbitrator got it wrong in how he decided that issue, but that he couldn't decide that issue to begin with because he's issuing a monetary award to a third party that's not a party to this case.
How did that amount get proven up?
It's based
where
on-
did this amount come from? Was there any consent to it? Or what happened as far as we've got this figure now that I assume Anna Levin didn't just pull out of nowhere? Where did this come from, and what was your client's position, at least at the arbitration for that?
Sure. The amount awarded was how much Mr. Stein was on his attorney's fees bills to Vincent and Elkins. And so it was Stein's alleged damages that he incurred as a result of Suzanne suing him. And he never brought a claim for those damages. He never brought a claim against anyone, not the trust, not Avi, not Suzanne, not in court, not in arbitration. So the arbitrator said, I'm still going to give him all of that money, and I'm going to make Suzanne pay it. And that's not something, we can't find a case in Texas law, and neither has the other side, where an arbitrator has ordered a party to pay damages to someone who's not in the case with whom they had not agreed to arbitrate any dispute. So it's just not.
Did your client agree to that amount?
No, we contested throughout the entire case that she didn't have any obligation for any amount. Those were unreasonable and unnecessary. He could not get them as a matter of law in federal court as part of it was a 12b6 motion to dismiss. He couldn't come this backdoor, sideways, convoluted way to get them in every step of the way. We said, don't owe this, no liability for this, and this is a ridiculous amount of money for a 12b6. So yes, it was contested throughout.
So how did it come up in the arbitration? I saw that there was this sort of stipulation that Gary Stein claims a certain amount of attorney's fees, and neither Avi nor the Children's Trust had paid those fees. But I guess I'm relating to Justice Hightower's question because I don't quite get how it even came up if it is outside the purview.
So Avi individually had alleged claims against Suzanne, and one of the claims that Avi alleged was that he owed money to Stein for Stein's attorney's fees. But throughout the case, in his discovery responses and in the stipulated facts leading up to the day of trial, the day of the arbitration trial, he conceded, it was undisputed, he hadn't actually paid anything to Stein. But he was coming into court asking the arbitrator to award it to him anyway. And he actually got on the stand, contrary to the undisputed facts, and said, oh yeah, I personally have paid a little bit to him. So then the arbitrator, without a request from any party, comes up with this 3-step or 2-step system where he says, okay, well, we're going to create those damages. We're going to make the trust, not Avi, the trust who didn't have claims, pay them to Stein, or pay them to the law firm's ILTA account until Suzanne pays them back, and then pay them to Stein. So the arbitrator came up with this all on his own.
Did he
No party
allegedly
asked for
pay
this.
them individually?
What's that?
I know there's a $140,000 figure in the record. Was that something that allegedly was paid? And I do see the discrepancy in the record. At one time we said, that hadn't paid anything, and then it's 140. Is the information or allegation that he paid those individually or on behalf of the trust?
He testified at the arbitration hearing, that he individually had paid some amount. We haven't seen documents or anything. It was just his testimony. And then later there is a letter from counsel saying Avi had paid X amount before, now the trust has paid X amount. And so it's all just what he claimed, but it was all on an individual basis, which is different for a number of reasons, but one being he did have individual claims in the arbitration, and his individual claims are arbitrable, but they're very different than the trust's claims.
At this time, had there been any express demand for indemnity under that provision in the trust agreement, or was there ever one at the time of the arbitration award, or this just?
No, I mean, Stein had not made a demand that we've ever seen. I believe Avi's testimony at the arbitration was that Stein had never formally made a demand. There was never any demand in any litigation or any arbitration by Stein at all. And I don't know that I don't believe there has been to this day. I don't know if the funds are still in their IOLTA account or if they've been paid to Stein. I just don't have any idea.
Can I ask you just to talk a little bit about the fact that there's a strong preference, I think, in Texas law for the use of arbitrations. There's also an assumption that arbitrations are to be enforced, and there are just a few exceptions that are created for when you can go outside of the arbitration. Which exception are you relying upon here?
So there's two, Your Honor. I want to start by saying...
And also, they are exceptions. These are not,
Right. So 2 points I want to make. The first one being there is a strong preference to arbitration when the parties agreed to arbitrate and about the disputes the parties agreed to arbitrate. So we don't get to that presumption if these aren't the parties and these aren't the disputes that they've agreed to arbitrate. And so the exceptions that we're looking at is on the ground to vacate the award would be because the arbitrator exceeded his authority by deciding an issue that wasn't submitted to him. And that would be a ground for vacating. And we would ask that it would vacate not only the award to Stein, but also the separate award of fees to Avi, because that issue is commingled with this issue, with the arbitrator thinking he could award it to Stein and remand just that portion of Avi's fees. The other issue, if the court did not vacate, we'd ask it to modify, and the ground for that is the arbitrator made an award with respect to a matter not submitted to him. Not properly submitted to him if the parties didn't agree to arbitrate this issue. He can't decide this issue, and so that would allow the court to just cut off this piece regarding Stein and then affirm the rest of modify that piece and affirm the rest of
And then where does that claim go? Stein's claim, assuming we modify as you've requested, where does that claim go that he has for indemnity?
So assuming Avi or the trust has paid him, then Avi or the trust, I guess, could bring a claim against Suzanne in court. I mean, the trust has not brought a claim against Suzanne anywhere yet, so it could bring this claim in court. It could not force it to be removed to arbitration, but I guess it could bring an indemnity claim
Just
in court.
Just into the 55th District Court where?
Yeah, I guess. I mean, gosh, I hope these parties have been litigating for a decade. I hope we aren't having further litigation, but yes, it would be outside of arbitration, I guess, is the simple answer to that. And so, again, I just ask the court to look, understanding that arbitration is contractual and it's also preferred, but only when it's in the bounds of that contract. And the reason we have what you mentioned is the statutory exceptions is because there are bounds to that. And so I ask the court to look closely at the language of the contract and closely at how the award does not match up with the language of the contract. And would ask that the court affirm, reverse, and either render judgment vacating the award or render judgment modifying the award, and if necessary, remanding some piece of it to be decided, the piece of it being the standalone attorney's fees claim by Avi individually. And I guess I have 45 seconds left, but I'll see you guys on rebuttal, so thank you.
Thank you, Ms. Fuller. Mr. Meade?
May it please the court, justices. I'm going to start with one basic concept first. Were these claims compelled to the arbitration? So let's start there, so we know what our playing ground is. To accept the other side's premise, you'd have to accept the idea that the Fifth Circuit, which has already decided this issue, so it's the law of the case, compelled Suzanne's claims against the trust. Really, it's the trustee, right? A trust is a fiction. It's the trustee. But she had sued Avi individually and as trustee. And that the Fifth Circuit compelled those claims against Avi individually and as trustee to arbitration. But somehow, the counterclaim by the trust, the trustee, for damages caused by wrongfully asserting those claims wasn't arbitrable. That's the essential premise that you'd have to buy. And so really here's where we are. We've got, I think, 4 big questions. One, are these claims arbitrable? The Fifth Circuit's answered that. That's the law of the case. So the next thing we've got to ask is, what did the arbitrator decide? First, the arbitrator decided who was in the wrong. Was there a breach of the agreement to arbitrate? Clearly there was. You refused to go to arbitration and had to be compelled by the Fifth Circuit. Did you sue for released claims? The arbitrator found that. Neither of those findings are things that the other side's asking the court to disturb, nor ones that the court could disturb under the purview of the arbitrator's broad discretion. The next question is, what damages did that cause? The arbitrator found that it caused damages in the form of Mr. Ron's individual attorney's fees in having to compel the arbitration, and in the form of having to file a motion for summary judgment to defeat released claims. And it caused damages to the trust in the form of an indemnification obligation to Mr. Stein. So then the next question is...
That bothers me for a second,
Sure.
though, because with that indemnification, in standard processes, we remand cases for insufficient evidence and things of that matter on attorney's fees. So if he's not there, to testify as to exactly those things, did she have the right to cross-examine or question the amount of the attorney's fees, such as you would in a litigation type standpoint?
Sure. I was our expert on attorney's fees, so I testified in the arbitration on the question of attorney's fees. I talked to the attorneys at Vincent & Elkins. I was involved in the Fifth Circuit, the state court briefing, the Fifth Circuit briefing on the issue. I knew what their fees were. I testified that they were reasonable and necessary attorney's fees. Ms. Lorber was the expert for Ms. Ron. She gave competing testimony on the issue of whether they were reasonable and necessary attorney's fees. And the arbitrator...
Does this information appear in our record?
That, I think the transcript of the arbitration is in the record, or it's not? Okay.
This is why I think we're hung
I'm
up
sorry.
on it, because we don't see
Sure.
it.
And so then the question would be, in a district court matter, you might say, is there factually sufficient evidence to support this? Really, the only question here is not, is there factually sufficient evidence, because that wouldn't matter in an arbitration. They can get it wrong. The question is, was it submitted to the arbitration? And I want to just point to a few, because Ms. Lorber made a statement that sort of taken the position that she was shocked to find out that the trust was asserting claims and not just Avi individually. And here's where in the record, I think, a few telling points. At one point, Mr. Ron filed a motion for summary judgment in the arbitration. They objected that you can't move for summary judgment in arbitration, but the arbitrator agreed to do it. But the arbitrator found in Mr. Ron's favor on a couple points, but found against him on one. And we had to go to a final hearing in the arbitration on it. And that was the question of whether Mrs. Ron had released her claims against him in his capacity as trustee. And what Ms. Ron wrote in the briefing was, on January 22nd of 2021, in her summary judgment response, Avi and the Children's Trust, that's in quotes, are moving for summary judgment. Avi responded with, Avi and the trust, this is in quotes, Avi and the trust also seek to recover fees incurred by Gary Stein in defending against Suzanne's baseless claims. On February 10th of 2021, Ms. Lorber responded, in quotes, Avi and the Children's Trust also seek to recover fees incurred by Gary Stein. Then we had a final hearing, and the arbitrator made a decision about the amount of those fees. One, made the decision that they were damages. Okay? That's not a decision that is subject to appellate review, and made a decision about what the amount of those damages were. Not a question subject to appellate review. So what they've done is they've constructed this argument that they never knew that the trust was a party to the arbitration. But let's back up. I went through how, in their own words, and this is in the record citations, they say the trust is a party going into the final hearing. And in fact, just as a final note, Mr. Ron, Avishai Ron's pre-hearing brief before the final hearing says, Avi, comma, in his capacity as trustee of the Children's Trust, comma, further seeks damages equal to Gary Stein's legal fees. All right, so that's all in the record. And then we rewind to what the Fifth Circuit compelled. Remember, Suzanne had sued Mr. Ron individually in his capacity as trustee for acts she alleged he did wrong in his capacity as trustee. Mr. Ron individually and in his capacity as trustee sought to compel those claims to arbitration, and the Fifth Circuit compelled them all. The answer of whether claims against the trust, which after we filed our motion for summary judgment, they non-suited in the arbitration, were subject to arbitration, is answered. The question of whether those claims cause damages and the amount of those damages flows directly from the Fifth Circuit's reasoning in that the claims were subject to arbitration. It wouldn't make sense to say your claims against the trust are subject to arbitration, but the trust counterclaim that you caused them damages and the amount of those damages in making those arbitrable claims are not subject to arbitration. That wouldn't make any sense.
So the arbitration language agrees to submit any dispute related to the MSA to Allen Levin for binding arbitration. I guess my question is, how are the attorney's fees related to the MSA when they weren't even in existence at the time that the MSA was created? They became to accrue like a year later after she filed her lawsuit. So at the time of the MSA, there were no attorney's fees from Stein.
Well, I would say this. The parties agreed to submit any dispute, obviously, so it's the broadest possible arbitration provision, right? After that, Mrs. Ron sued Mr. Ron and sued Mr. Stein for alleging that Mr. Ron in his capacity as trustee conspired with Mr. Stein to steal assets of the divorce prior to the execution of the settlement agreement. So events occurring prior to the execution of the settlement agreement. All of the allegations related to events occurring prior to the execution.
This is for attorney's fees. What this claim is
Correct.
will come later.
Correct. Those assertions in violation of the release under the settlement agreement caused damages. Those damages were awarded by the arbitrator. Their real complaint is not they think the arbitrator got the damages number wrong. You heard Mrs. Lorber say that, but that's not really something she knows she can't appeal that. So she says the arbitrator did it in the wrong way. But this is the interesting part. This is why you agree to an arbitration. In fact, the way the arbitrator did it here, I can imagine if he'd done it differently, the complaint we'd be hearing from the other side. If the arbitrator didn't order Mr. Ron to actually pay those legal fees before ordering Mrs. Ron to reimburse the trust for those, she'd be complaining they're just hypothetical damages. So what, under the arbitration or the indemnity provision of the trust document, and to back up for just a moment, it helps to know this. Mrs. Ron was the grantor of that trust, so she created the trust. So she signed the trust, so she knew the terms of that trust. That trust had a mandatory indemnity provision. The trust shall indemnify the trust protector for damages incurred. So it was logical that if you sued the trust protector was going to be entitled to damages. Now, one of the things Mrs. Ron objected to repeatedly throughout the arbitration was, Mr. Stein isn't here, he's not a party, there are no actual damages. And so, in his broad discretion in fashioning a remedy, what the arbitrator did is he made sure that the trust paid that indemnity obligation before requiring Mrs. Ron to pay the damages. And if anybody had a right to complain about that, hypothetically, if it were that the payment to Mr. Stein, it would have been Mr. Ron to say, wait, you can't make me pay a third party. But of course in arbitration you can, and we've cited a case involving the AAA, and it makes sense if you think about, I think the easiest way to think about that, it's not what happened here, but you could think about it like this. Could parties agree to have an arbitrator determine who has to pay a third-party debt. If you wrote up an agreement that way, clearly you could, right? So if you can do that, which is a narrower arbitration provision, then you resolve any dispute between these parties. And this is a 2014 divorce, right? 10 years later, we're still dealing with litigation between them. And thankfully, the Fifth Circuit says, that's all going to go to Mr. Levin. If y'all have disagreements and fights, I guess they could come up with something entirely new, but luckily they live in different states and maybe they won't. If you come up with something that is related to this agreement that you reached, right? And by the way, when you look at the language of the MSA, I think it's worth noting that the parties agreed to put each other back in place. Mrs. Ron had been removed by the trust protector as the trustee of one of the two mirror trusts. Mr. Ron had stepped down voluntarily. In this agreement, they are both agreeing to allow the other to go back in place as trustees of the trust. They're agreeing to release all claims, and if we have any disputes about this, we're going to put them into the arbitration. And Ms. Ron feels confident that she won the first arbitration between the parties. She feels like she lost the second arbitration between the parties. And that's the real complaint here, is she lost. And so they try to construct arguments that aren't even real, like she's having to pay Gary Stein damages. But she's not. She's having to pay indemnity to a trust that she formed, knew the language of, and caused, according to the arbitrator, a set amount of damages to be incurred by that. And the fact that the arbitrator crafted a remedy that took care of the entire dispute, I was thinking about that when I was reading through some of the cases. One way you can find reversible mistake by an arbitrator is that they haven't fashioned a complete remedy. And it's not that you reverse or that you reverse and render, but you reverse and remand to fashion the remainder of the remedy. Here, that would be what Ms. Ron was complaining of. If she would either be complaining that we didn't have actual damages if we hadn't paid Gary Stein, or that we should be required to pay Gary Stein, because she spends a bunch of time in her briefing saying, I didn't even get a release from Mr. Stein in exchange for this. I didn't get a receipt from Mr. Stein. I don't know what that has to do anything. But if the remedy had not been fashioned to require Mr. Ron to actually reimburse that as trustee, the complaint would be that there was an incomplete remedy. You're requiring me to pay the trust for an indemnity obligation, but not requiring the trust to pay it to that third party. And so the arbitrator fashioned, I think, what is a clever remedy to make sure that the trust satisfied that indemnity obligation as a condition precedent to Mrs. Ron having to pay the damages. But it wasn't necessary. The arbitrator could have found the damages and awarded them to the trust, but not required the trust to pay those damages to Mr. Stein. That would have been one remedy. They also could have found a different amount of damages. The arbitrator had discretion in fashioning a broad remedy on issues put before it by the Fifth Circuit. And so, if you have any other questions, I'm happy to answer those.
In the Fifth Circuit, there's not any direct reference to Stein's claims for attorney's fees because they weren't in existence then before the Fifth Circuit, right?
Correct.
So they would have had to have anticipated that if they meant that to be part of the arbitration agreement.
Correct. They would have had to anticipate. They couldn't have anticipated that at the time. Right. Mr. Ron submitted all of his claims in arbitration. This was the first time we arbitrated in front of Mr. Levin, Mrs. Ron challenged it. The second time we arbitrated in front of Mr. Levin, Mrs. Ron challenged it. And I believe it was this Court of Appeals that forced her into arbitration the first time, and the Fifth Circuit forced her into arbitration the second time. And on that record, the claims were Mr. Stein's. Mr. Stein was simply moving to dismiss the claims against him under 12b-6, failure to state. Mr. Ron, who had been sued for conspiracy, individually and as trustee, was saying, all of the claims against me have to go to arbitration. And that's really the corollary that I was speaking of. It wouldn't make sense to say, you've sued me as, cut out the individual part. You've sued me as trustee. The Fifth Circuit says all those claims against you as trustee must go to arbitration. Now, I'm going to say that because you filed those, you violated a provision of the same document that required the arbitration, the MSA, that released me. And because of that, you caused damages. And you caused other damages. But that those claims somehow are not arbitrable. Which is really not even the argument being made in the brief. The argument being made in the brief is that the trust didn't appear at all, right? That's the argument being made in the brief, is that the damages, two main arguments really being made. You can't award damages to a third party. Logically wrong on what I was just talking about. You could specifically write an agreement that says, arbitrator, you decide which of us owes this debt to this third party. And this is a broader agreement than that. Also not what happened. Mrs. Ron was required to make a payment to a party to the arbitration. So then their other argument is the trust wasn't even a party to the arbitration. And yet, Mrs. Ron's claims against the trust were exactly what was compelled to the arbitration. And the trust clearly, I went through a number of references in the record, clearly asserted counterclaims, including claims for the fees that Mr. Stein incurred. And so it's impossible for me logically to separate the concept that you can compel a claim to arbitration, yet not the counterclaim, the corollary claim to that. And so clearly, if Mr. Ron was a party to the arbitration as a trustee defendant, he was a party to the arbitration as a trustee plaintiff as well, on the same claims for the same cause of action. I think that I want to make sure. I think I'm going to look through if there were any other points, but I'm listening if you have any other questions, since I've got a couple of minutes.
I do have a question.
Oh, yes.
Is there anywhere in the record where we can see that Stein sought reimbursement?
There is not anywhere in the record that Stein sought reimbursement. What happens is, and this is the argument that we made to the arbitrator, the specific agreement requires, it's a mandatory indemnity provision, and Mrs. Ron made the counter argument that Mr. Ron had not paid, and she said, and he won't, he never will make this payment. So the arbitrator said, well, I'm going to make sure you do. I'm going to make sure you make that payment. And so the arbitrator closed the loop in what I think, I didn't like it at the time, is an elegant and maybe something only an arbitrator could do, right? Elegantly, the arbitrator said, okay, you want these damages for reimbursement of this indemnity? I'm going to make sure you pay them to the party who would receive that indemnity, and then that'll be a condition precedent to the damages. So you had a separate finding in the last 50 seconds here. First, you had a finding of a wrong. You violated the MSA by bringing these claims. Second, you had a finding of damages. You caused damages over here to Mr. Ron. You caused damages over here to the trust. And then a closing of the loop to make sure that there was a complete remedy, and I think rather elegantly fashioned at that. Thank you, Justices.
Thank you, Mr. Meek. Ms. Sorber?
Your Honors, two opposing counsel started by saying that these are the 4 questions at issue. I think we can narrow it down to 2. Was there a pleading that in this arbitration that would support an award of Stein's fees to Stein, or an award of Stein's fees as damages to the Children's Trust?
There were pleadings in the arbitration?
What's that?
Pleadings in the arbitration?
Yes.
Okay.
And he says, how could I be confused about whether the Children's Trust had brought a claim? Well, on June 16th of 21, Avi filed a jurisdictional objection in which he says the Children's Trust has never appeared in this case and does not do so today. And then after that, 3 months later and 4 months after the pleading deadline, he tried to amend his petition to allege claims on behalf of the Children's Trust. I objected to the arbitrator, and they withdrew the amended petition. And this is all after they have said the trust has never appeared in this case. And so, of course, I was surprised that the Children's Trust was now wanting these as the Children's Trust damages rather than as some damages Avi was claiming in a convoluted way.
Ms. Lober, did you appear as the expert on, with regard to the amount of the?
Yes, we were about the amount of all fees in the case, not just on.
But on the, specifically the fees that were charged by?
Yes,
Okay.
we were competing experts on that. And so my second point is not only is there not a pleading, but is there an agreement to arbitrate these claims? He keeps trying to say that this is related to the MSA because it's related to the release in the MSA. And this is important because the release releases Avi. So release of Avi is related to the MSA. There is nothing in the MSA that releases Stein or that releases the Children's Trust or says Suzanne cannot sue the Stein or the Children's Trust or has to arbitrate with Stein or the Children's Trust. Not in there and not in any other agreement. So the argument that all of this was released and therefore it's all related to this MSA is just factually wrong because as the arbitrator held in the arbitration, his summary judgment order, the Children's Trust is not a party and therefore cannot be a party to the release. And so they can't get in, they can get Avi's claims in through the release, but they can't get the claims against these other entity and individual in through a release when there is no releases to that individual.
Can I ask you, would you agree with Mr. Mead that there is no real argument on your side about the way that the attorney's fees were calculated? Or your whole argument is really under A3 about whether this claim was before the arbitrator properly at all. It is not about the means amount, or would you agree with that?
It's a liability for the fees question, not an amount. I mean, the fees are calculated.
I'm not asking it very articulately. What Mr. Mead said is that because all of these things are sort of consigned to the arbitrator, the method of calculating the fees, whether they were reasonable, the sort of particulars of how that figure was arrived at, that is not what you're really contesting. What you're contesting is that issue should not have been before the arbitrator at all. I'm just trying to narrow it a little because it sounded like you were saying that you wanted to contest the amount and that was a claim under A3, but
no.
I want to make sure I understand you
right.
properly.
Yes, you're correct that what we're arguing is that the arbitrator did not have authority to decide that issue. If the arbitrator had authority to decide that issue, the fees were calculated as they are in a lot of cases based on attorney's fees records. But so that's not our point. It's the arbitrator did not have the authority to decide the issue of whether the Children's Trust owed an indemnity agreement to Stein and how much, because that was not something within the party scope of their arbitration agreement. So yes, yes. And so I wanted to point out one other thing that came up at opposing counsel's arguments is he said the parties could agree to figure out liability to a third party and to have that be arbitrable. They could have, but they didn't. They didn't mention this third party claim in their MSA. It didn't exist at the time of the MSA. It didn't exist at the time of the Fifth Circuit. And there is a Fifth Circuit's opinion, and there is a difference between whether Suzanne's claims against Avi and the Children's Trust, which reference provisions of the MSA, are arbitrable, and whether claims brought by Avi and if the Children's Trust actually brought any claims that do not reference the MSA. They reference a release as to Avi, but they're not relying on a release and trying to get from Stein's fees, because Stein wasn't released, and neither was the Children's Trust. So I thank you for your time, and again, I ask that you reverse.
Thank you, Ms. Lober. The case of Suzanne Ron versus Avishai Ron, individually and as trustee of the Suzanne and Avi Ron 2012 Children's Trust, has been submitted to the First Court of Appeals. I thank you for your arguments.
Thank you, Justice.